So everybody, how you doing? Another week, another dollar. Real quickly, we're going to talk about, and don't run away, because it relates to a lot of things that are going on. But we're going to talk about what happened with AB5 Prop 22 this week, because yes, it directly affects the gig workers in California. But because so many other laws were modeled, New York, Washington State, Minnesota, were all modeled off the Prop 22 thing, we need to talk about what happened there. I mainly because I want to make sure you guys understand Prop 22. I actually had somebody email me or make a comment on a video saying that you don't live in California, you don't understand it. Well, I've had Professor Vina Dubal on, who is pro AB5. And who helped write AB5 for Gavin Newsom. She's been on the podcast. I've had Kim Cavan, Karen Anderson, Lisa Rothstein. These are all the experts in this field. So I've done gig work since 2015, and I just want to make sure that you guys understand that even though I don't live in California, I tell people in California often the details of AB5 behind Prop 22 because they don't understand. Most people don't understand. A lot of people are following what's going on with it now, and that's why we're going to go here and see if we can get through this, because the timeline does jump around a bit. So this week, Tuesday, Uber lost its long-running attempt to overturn a California law that would require it provide employment rights to its drivers. So this is Uber fighting California on we don't want to be paying this Prop 22 anymore. Part of this goes to the challenge of, is it constitutional? Does it meet with the California Constitution? We'll be coming back to that for sure. But they lost that ruling, and they had already won one appeal in last year. So, but this was, again, the ruling by the Ninth U.S. Circuit Court of Appeals could have major implications depending on what the state Supreme Court decides now. So let's go through this. Uber and Postmates, a food delivery platform, Uber now owns. Postmates is still around in California. The California people know that. But yes, they can keep that brand name just like they could have with Corner Shop, but they didn't. But so Uber, let's just say Uber, alleged that AB5 violated their rights under the Equal Protection Clause of the state and U.S. constitutions. And this gets really important because this AB5 and the ABC test are very important. So we will roll through that real quick. But AB5 requires ride-hailing and delivery companies to treat their workers as employees instead of independent contractors, and codifies the so-called ABC test to determine which workers should receive benefits under that law. And so Uber, the Flex Association, DoorDash, Uber, Lyft, Instacart, they couldn't pass the ABC test. But for those that haven't watched a lot of the content on this channel where I've had these professionals on from California, there's a lot on this channel, but AB5 destroyed livelihoods. Let's first forget the gig economy for just a quick second. It destroyed livelihoods. People who had 40-year careers, who had built their own businesses. You could no longer, if you couldn't pass the ABC test, you could not be an independent contractor, that's just wrong. Since the day this country was founded, you can be an independent you can work for yourself. That's freedom. That's what this country is. But here, real quickly, I want to run through, it's been a while since we've done it. I won't go through all the wording in the beginning, but if you go to the labor code in California, and this is for the people who are misunderstood on how this works, the new provision was 2750.3, Section A, Section 1. And it talks about the ABC test, and it walks through. So a person giving services to another company to be considered independent contractor or employee depends on this three-pronged test. So you have to meet every one of these criteria. Otherwise, you can't be one. So A, the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under contract for the performance of the work and in fact. The only company that's really pushing buttons with that are any platforms for the A part in terms of gig work. The only ones having real issue with this are ones that have tiers. If you have tiers and levels and places you can hit, you're going to have a problem with that one. B, this is the one that basically, it doesn't even matter. Everybody pretty much fails it. I'll give you an example of somebody that doesn't, but it's very rare. So B, the person performs work that is outside the usual course of the hiring entity's business. So it's a rideshare company, right? I mean, they could say tech company, but they could still break it down and go, no, you're just, I mean, even if you say it, 99% of your work income is rideshare. So they're a rideshare company, that's understood. They're not even arguing that point anymore. However, they're a rideshare company, so you can't be an independent contractor for them if you do rideshare. You follow? Like, okay, so if Uber has an office, I mean, they do, but let's say that Uber has an office and they're freelancing to all these drivers and they're independent contractors because of Prop 22 in California. But let's say that now it gets challenged, all of a sudden it's not. Let's just pretend for a minute. But now let's talk about a plumber independent contractor. If Uber for the office calls a plumber and says, we need you to come fix the plumbing, that person does work outside of the normal business that they do. So they're a rideshare company, right? They're not plumbers. So if some plumbing breaks and they call in a plumber, that can be an independent contractor. The last prong of the test is the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So that one we're pretty much all in the clear on. The problem with this ABC test is it's in almost every state. And I mean, really, they're just pulling out these old laws from like tort law era. So it's pretty crazy. So in 2020, AB5 went into effect, and the companies filed an injunction in January of 2020, waiting till November to have the Prop 22 ballot voted on. In November of 2022, or of 2020, they had Prop 22 on the ballot. 58% of Californians voted yes on Prop 22. We want this. That's 3 million more votes than no, just so you get the percentage part of how much difference that is. So it was an overwhelming yes, so it went into effect. Now back into the courtroom. So we also have 1.4 million gig workers in California doing app-based driving and delivery and rideshare. So Uber is now, they're giving the pitch that we all can understand. Canada's going through this up in British Columbia right now too. But they're giving listen, keep doing this. Prices raised for the customer. It's basically like we can meet these standards that you're requiring, but prices raised for the customer, so less volume, and there will not be as many rides for the drivers, so less volume. So in many cases of these states, what ends up happening is the drivers end up saying, basically, I thought I was going to benefit from this, but I'm making the same amount, but putting in more hours. Now with delivery in California, there's an exception. I know a lot of you delivery drivers do great, and Prop 22 helps you, but that was by accident. If you put that timeline together, the pandemic hadn't even started when all this went in place. Uber argued in court on Tuesday that AB5 has many exemptions for companies that pay workers in different industries. They started listing off some of the things. They included live performers, music professionals, real estate appraisers, and more. There's a list of 608 that you guys have seen me list that were not exempt, though. And those careers are killed. So, I mean, it's just a big mess. But here's the breakdown of it all. So, Prop 22 is being challenged. There's some constitutional issues in there too. Like, is it, because one of the deals in Prop 22 was that they took away, or that you didn't have the right to assemble, meaning form unions, private unions, whatever, but that you would get some other perks. And that was a deal. Also, a big problem is that the voters of the state already voted on it. And then these lawyers clamped on after. And that's a big problem, because how do you go back and go, hey, that remember in 2020 when we all voted on Prop 22? Well, we're going to overturn that now. Well, why, that's way too far to tell the voters, hey, you voted one way, but we're going to flip that now because it wasn't constitutional. Because they'll just say what I've thought a million times. Why didn't you know that wasn't constitutional when it was up on the ballot then? I mean, you have enough lawyers. But here's the outcome chances. So here's how it's being viewed. And I know a lot of gig workers do, especially the delivery ones, like the Prop 22 out in California. The rideshares really don't see much from it. If Prop 22 is upheld, it would be a huge victory for Uber and the other gig companies. Like, they want that upheld because otherwise they're under AB5. And they know no driver in California will pass the B test, or the B prong. But Tuesday's ruling means they would still be on the hook in any cases where they are found to have violated laws related to worker classification before Prop 22 took effect. So this is where it gets real confusing, because it's like they can go back and go, this person, which is what the federal version is, the Biden administration rolled out earlier this year. So, which just huge messes. So they're saying, okay, well, that's just what it is. If Prop 22 is thrown out, the appeals court ruling means, quote, these companies do not have this case to fall back on to exempt themselves from having to provide basic employment protections. And that's from Vina Dubal, who's been on this podcast before. She's the law professor at UC Hastings. The Supreme Court now has 90 days to file an oral argument. And so in August, we will have a final decision on all this. Finally, Prop 22 will either come to an end, it will be put into fruition forever. I mean, they could still challenge, but it'll never get a real date again, and so on. In my opinion, there are so many better ways to solve this than following the road that California took. And I'm just going to start with one today, the biggest one: desaturation. And there's a few ways to do it, but basically, we got to get drivers off the road, because the more drivers, the less rides you can do. And that's 13 minutes, and just 13 minutes.